Let's turn to the last kind of amendment that you can make to a pleading, probably the weirdest kind of amendment as well, called relation back. Relation back is a provision under 15C that allows a person to make an amendment to substitute or add a party that should have been there in the first place. So 15C is available for all pleadings, but let's just take it from the point of view of the complaint, because that's where it usually happens and that's where it's easiest to see. So what's the effect of adding a party under relation back? The amendment to the complaint that adds the party relates back to the original pleading. What does that mean? It means we treat that amendment as though it were in the original pleading, even though, as a factual matter, it wasn't. So it's kind of a legal fiction where we basically pretend that you had the defendant there in your complaint all along, even though, in fact, you didn't. Why is that useful? Why can't I just say, oh, Rule 15 allows me to amend my complaint. I'm amending my complaint to include a new defendant or a different defendant now that I know something that I didn't know before? Well, in fact, you can do that. You can just use normal amendment to add or replace a defendant in your complaint, but you may be prevented from doing that if your statute of limitations has run. And Rule 15C allows you to get around statutes of limitations to include a defendant who wasn't there to begin with. So just to make sure we're all on the same page about what a statute of limitations is, let me go into that for a sec. A statute of limitations limits how much time can pass between the event that I'm suing about and the date I file suit. So really simply, you and I get into our car crash that we're always getting into. You have 3 years, let's say, from the date of our car crash to sue me. So the statute of limitations tells you you have 3 years to sue from the date that the event happened. If you don't sue within 3 years, you can't sue anymore. You have lost your cause of action. Let's say we get into a car crash and 4 years later you get around to suing me. My answer is going to include the affirmative defense that the statute of limitations has run and therefore you have no claim. I could also put that argument into a 12b6 motion and say you haven't stated a claim on which relief can be granted because even assuming we crashed into each other and even assuming I negligently caused you injury, you don't any longer have a claim under our state's tort law because the statute of limitations has run. Where do you find your statutes of limitations? In varying places. Sometimes they are written into the law that provides a cause of action. So here's something that people aren't allowed to do, and if they do it, then the people they harm have X number of years to sue about it. Sometimes you just have a list. So I'll show you one in a sec. Here's the New York CLPR, part of a list saying the following actions must be commenced within 3 years. So these kinds of actions are all dealt with at different places in the law, but we have one long statute that basically says all of these kinds of actions have a statute of limitations of 3 years. And let me just walk through a couple of examples for you. So these should be recognizable: an action to recover damages for an injury to property, an action to recover damages for a personal injury. So if you and I get in a car crash, you're probably looking at these two, and you'll be interested to know that you have 3 years from our car crash to sue about it. Here's another one that has an interesting aspect that's really important for statutes of limitations. Say we have an action to annul a marriage on the ground of fraud. I don't know how much this happens anymore. This feels like a very kind of 19th century sort of provision to me, but who knows? Maybe marriage is in a more perilous state than even I recognize. But the important thing here is think about what happens in the case of a fraudulent marriage that is different than the case of a car crash. If you and I get into a car crash, it's going to be pretty easy to put a starting point on that statute of limitations. We got in a car crash, and 3 years from that car crash is how long we can sue about it. But what about an action to annul a marriage on the ground of fraud? Say I marry somebody because they have fraudulently induced me to marry them, but I don't know about that because they're very successful in their fraud. And we're married for years and years before I find out that they actually fraudulently induced me. Does the statute of limitations run from the day they proposed and I accepted? That would be silly. Does it run from the day that we sign the marriage certificate and therefore are legally married? Or maybe does it run from the time when I find out that they committed a fraud? So often statutes of limitations for things that are not obvious will have a specification about when in the process the clock starts ticking. So here in New York, for an action to annul a marriage on the ground of fraud, the time starts when the plaintiff discovers the facts constituting the fraud. So my knowledge of the fraud marks the start of the stopwatch. And from that point, I have 3 years to sue. Okay, so that's statutes of limitations. Let's get back to Rule 15C, relation back. Relation back allows you to add or substitute a defendant or other party on your pleading and act as though you had already had them there at the very beginning, even if the statute of limitations has already run on that action. And they're allowed under certain very particular circumstances. The first is a statute of limitations might specifically say you're allowed to sue on this for 3 years, except that you can substitute parties beyond that, or something like that. This is pretty rare, but the rules provide for that possibility for the state or the federal government, whoever's writing the statute, to decide for themselves how relation back should work. In the alternative, assuming the statute of limitations doesn't mention relation back, we have a default that's pretty complex. So let's walk through it. One is whatever you're adding arises from the conduct, transaction, or occurrence in the original pleading. So if I'm adding a new claim or a new defense, if I'm adding a new defendant, they have to be part of the thing that I was originally suing about. So what this means is you don't get to start a whole new lawsuit within the lawsuit once your statute of limitations has run by using relation back. Rather, you can specify and correct stuff that was wrong or inaccurate in your original pleading after the statute of limitations has run. Okay, so I think that's pretty straightforward. And just watch out this transaction or occurrence language. You will start seeing it over and over and over throughout this class. This is a standard form, a way of saying the events in the lawsuit. Okay, but then you need some other stuff. Here's the first and. You need to make sure that the new party had enough notice not to be prejudiced in mounting its defense. So this is if you're substituting a new party, right? If you're just adding to a claim, you don't have to worry about this. But if there's a person named in your complaint who was not named before, you need to ensure that they had enough notice not to be prejudiced, in other words, disadvantaged in mounting their defense, and that they knew or should have known that the action should be against them, but for your mistake, but for the pleader's mistake. So 15C relation back is typically used in a couple of different circumstances. It's especially useful when the plaintiff sues the defendant under the wrong name or the wrong entity. So say I sue a subsidiary, but because of the legal relationship between the subsidiary and the parent company, really I should be suing the parent company. Or say I sue the company under one name, which is its popular name, but it legally uses another name. So there's actually a case on point, Krupski in 2010, that said the company had constructive knowledge. Constructive knowledge means even if we don't prove that you actually knew something, we can assume that you knew it because the circumstances are such that a reasonable person would know it. So a company that's operating under two different names and gets sued under one of them actually knows that it is the party that should be being sued. Or in a simpler situation, say, I think that my harm was caused by one person, but it was actually caused by another. You and your brother are driving in a car that crashes into me, and I sue you, but it turns out you were the passenger and not the driver, and your brother was the driver, but your brother knows that I'm suing you, and your brother knows that he should really be the object of my lawsuit, something like that. So let's think about 15C for the cases that we've read so far, and just take a minute to think through the requirements of 15C and see if they would work for either of these plaintiffs. And we'll get to this in class when we talk about this stuff. So question one, could Zelinsky have used Rule 15C? So Rule 15C, by the way, is a fairly recent addition to the rules. So let's just assume that it wasn't available for our plaintiffs here that we've dealt with. Think about Zelinsky and whether this could have been useful for him. And now think about Beek and whether this could have been useful for him. Could Beek have used Rule 15C? Just walk through the rules requirements and see how it plays out in both of these cases. There's another question that Rule 15C raises, which is sometimes you don't mistake the identity of your defendant, you just don't know it. So if I am assaulted by a security guard at a bank, I know that it's a security guard who assaulted me, but I don't necessarily know that person's name. I can find out their name in discovery, but I don't necessarily know it to put it on my complaint. So what happens in that kind of situation if I know the role that the person was playing, and I'm pretty sure that I can figure out their name through discovery, but I don't actually know their name when I file suit? Well, we actually have a way of dealing with that. The complaint can name John Doe or Jane Doe as a defendant. That's a placeholder until I find out the guard's name. So you can actually use, there's no specific rule about having to use John Doe, but John Doe's generally the generic name in law for someone who we don't know who it is. So the complaint would be Bernstein versus John Doe, and then usually it would have a description, so the security guard at the bank or something like that. And then I can go back and amend that pleading once I find out in discovery who that person really is. The question, though, is what if I don't find out John Doe's real name until the statute of limitations is already run? Can I then use not just the normal Rule 15 amendments, but specifically Rule 15C relation back to get around that statute of limitations and replace John Doe with the actual person's name? So think about that question as you read the next case. And you can consult, I've reproduced the Rule 15 requirements on the next slide, so you can just consult that as you're thinking about this question and the Beek and Zelinsky questions.